So at the injunction hearing, if the court makes a finding of family violence, the parent who is found to have committed or engaged in an act of family violence is not going to be a joint managing conservator under state law. In other words, they stand to risk a great majority of their parental rights. And maybe the only right they'll keep is what's called a possessory conservator, which means they have the right to see the child, and it's on whatever schedule the court deems appropriate, depending on the violence that has occurred. It might be no possession at all, at least to start with, or some sort of graduated possession or supervised possession. And that obligation of child support and health insurance and health support will continue, will be imposed. So no parental rights, almost no contact, don't get to decide where they go to school, don't get to talk to the school teachers, don't get to talk to the doctors. Think about all those parental rights. It's a lot. And those can all be extinguished just like that by committing family violence. So it's something to take very, very seriously. The state of Texas outlines some tough penalties for those who commit family violence for a good reason, because children are victims, and they have, or can be victims, and they have no advocate. They are not adults. They can't stand up for themselves. They cannot fight back. They didn't ask for it. And so the courts are given broad discretion with how to deal with family violence. Another thing that can happen at an injunction hearing is that an injunction may be made permanent, which means it's not reviewable for up to 24 months. And if there's a no contact order issued, that possessory conservator may have to stay away from their child for up to 2 years. So it can be a very big problem to have that finding of family violence made against a client. And again, the point of this is to ensure that of those 1 in 10 people who may be a victim out there, know that there are resources to help you, and that the state law is there to protect you and the children of family violence from these bad actors. And it's unfortunate. We see it all too often in our child support, in our CPS cases, and we see it frequently in our criminal cases that have some sort of parallel family law case going along with them, where children and or spouses who are victims of family violence, CPS steps in to remedy that, take those kids out of that dangerous situation, and criminal charges ensue along with a family law proceeding where termination is sought. So termination of parental rights. So no rights whatsoever. Anyhow, these are all things to think about, and to know that state law is there to protect our citizens, and our legislators do a very good job under the Family Code in ensuring that the laws are written in a favorable way to protect the victims of family violence.